Group 14A, provisional sentence proceedings. In tradition and background, basically, provisional sentence is an unusual and extraordinary remedy. Procedurally, it may be described as a hybrid containing elements of both action and motion procedures. A provisional sentence action is commenced by means of a provisional sentence summon. But the pleadings at the provisional stage are in the form of affidavits. The provisional sentence procedure may be utilized for one cause of action only. Actions based on liquid document. In a provisional sentence summons, the defendant is called upon immediately to pay a sum of money to the plaintiff based on the liquid document, a copy of which must be annexed to the summons. The provisional sentence summons further informs the defendant that if he or she fails to make the required payment, he or she is required to appear in court on a specified date, either personally or by a legal practitioner, to admit or deny liability for the claim where the mortgage property is involved, to state why the mortgage property should not be declared executable. If the defendant chooses to deny liability, he or she is required to deliver an affidavit setting forth the grounds of his or her defense to the claim. The defendant is also required to admit or deny his or her signature on the liquid document, and the liquid document was allegedly signed by an agent of the defendant, to state whether he or she admits or denies the signature or authority of the agent. If the defendant does not deny liability and delivers an affidavit, the plaintiff is entitled to deliver an replying affidavit. The court would then decide liability of the defendant on the affidavits only. No oral evidence may be tendered or heard during the provisional stage unless the defendant denies the authenticity of his or her agent's signature. If the authenticity of the signature is in dispute, oral evidence may be heard on that aspect and on that aspect alone. If the court refuses to grant provisional sentence, it may be, depending on the reason for the refusal, mean the end of the action, or it means the end of the action. This will be the case where the court is not satisfied that the document upon which the action is based is a liquid document. In all other cases, the court will order the defendant to deliver a plea. The normal action procedure will apply from that stage. If the court grants provisional sentence, the defendant is required to satisfy the judgment before being permitted to further defend the matter. In the terminology, provisional sentence procedure is referred to as entering upon the principal case. Requirements for the grant of provisional sentence. The requirements for provisional sentence are the following. The plaintiff's claim must be based on a liquid document. The plaintiff must satisfy to the court as to the onus upon him or her that the defendant is unable to satisfy the court in respect of the onus upon him or her. Liquid document in Rich versus Largerway, it was held that a liquid document is one upon which a proper construction thereof evidences by its terms and without resort to evidence extrinsic thereto an unconditional acknowledgement of indebtedness in an ascertained amount of money, the payment of which is due to the creditor. If a document evidences all these characteristics, it is one upon which a provisional sentence may properly be granted. From this definition, it is evidential that the elements of a liquid document are as follows. A document which manifests certain characteristics. The characteristics must be established without resort to extrinsic evidence and by reference to only the document. An acknowledgement of indebtedness in an ascertained amount of money, the payment of which is due to the creditor. The acknowledgement of indebtedness should be unconditional. The signature of the deemed signature of the debtor or the latter's agent. The onus of proof on the plaintiff. The plaintiff must establish that the document being sued upon is a liquid document. He or she is the creditor. Ex facie the document, the defendant is liable. In the absence of any defense by the defendant, the court must grant provisional sentence in the plaintiff's favor. The onus of proof on the defendant. The defendant may oppose the provisional sentence in two ways. He or she may contest the liquidity of the document. He or she may contest the authenticity of the signature on the document. He or she may contend that the event happening which payment is made contingent has not been complied with or has not taken place. If the defendant puts the liquidity of the document in issue, the onus is on the plaintiff to show on a balance of probabilities that the signature is of that of the defendant or his or agent, that conditions have been complied with or have taken place, as the case may be. Appealability of a judgment at provisional sentence stage. When provisional sentence is granted, it was held in Afshaklo versus FNB. I can't pronounce that. Everyone can see what it means and the citation of the case. But when a provisional sentence has been granted in the High Court, the common law does not provide the defendant with any right to appeal, but classifies a provisional sentence as a pure, simple interlocutory order against which no appeal can lie. So there's no appeal in terms of the above mentioned case. For a judgment or order to be appealable, it must have three attributes. The decision must be final in effect and not susceptible to alteration by the court of first instance. It must be definitive of the rights of the parties, and it must have the effect of disposing of at least substantial portion of the relief claimed in the main proceedings. The decision to grant provisional sentence is not final in effect, and is susceptible to alteration by the court, here in the principal case, even as to the question whether the document relied upon is liquid or not. The provisional sentence is further not definitive of the parties' rights and does not finally determine the issues between the parties. In determining the nature and effect of a judicial pronouncement, not merely the form of the order had to be considered, but also its effect. The grant of provisional sentence is therefore not appealable. This was the decision followed in Smith versus Scania, South Africa, the 2004 case. In this matter, it was also held that it was possible that in exceptional cases, the application of the requirements for appealability to a provisional sentence judgment. The process, let's go to the process for execution of execution in terms of Rule 36, the process in execution. The process of execution of any judgment for the payment of money for the delivery of property, whether movable or immovable, for the judgment shall be by a warrant issued and signed by the registrar or the clerk of the court addressed to sheriff. This process may be sued out by any person who's in favor of any such judgment shall have been given. If such judgment is then not satisfied, stayed, or suspended, this process may at any time on payment of the fees incurred be withdrawn or suspended by notice to the sheriff by the party who has sued out such process. Collection process from the debt to execution, 3 phases: obtaining judgment, attaching the property, arranging the sale and execution. Rule 36 above deals with the process to be followed in executing judgment. Important types of warrants: warrant of execution from 32, warrant of ejectment from 30, warrant of delivery of goods from 31. The warrant of execution is used most often, and it is in terms of this warrant that either movable or immovable property may be attached to be sold in execution. Normally, the plaintiff must first attach the movables. And as we continue, the general rule is that warrant of execution against movables property may be issued after judgment, and if no sufficient movable property is found, a warrant against immovable property may then be issued. In practice, a warrant of execution is issued at the time when the judgment by default is granted. If no attachment is made in terms of the warrant, the execution creditor is not entitled to recover the costs of the warrant nor the sheriff's fee from the debtor. So it remains your own cost, or basically maybe the plaintiff's costs. Prior to considering the execution process, a regard should be had to Section 67 of the Act. In this regard, to items that are exempted from execution, the necessary beds, bedding, and wearing apparel of the execution debtor and of his family, stock, tools, and agricultural implements of a farmer, insofar as they do not exceed the value of the amount determined by the minister from time to time by notice in the Gazette. The supply of food, drink in the house, sufficient for the needs of such debtor of his family during 1 month. Tools and implements of trade insofar as they do not exceed the value of the amount determined by the minister from the time to time by notice in Gazette. Professional books, documents, or instruments necessary to be used by such a debtor in his profession, insofar as they do not exceed the value of the amount determined by the minister. Such arms and ammunition as such a debtor are required by law, regulation, or disciplinary code to have in his possession as part of the equipment. The amounts must be reflected on the warrant. Capital amount or outstanding balance of the claim, judgment cost, bill of cost has not been text yet, words text should be inserted. Interest, the rate and the date from which it has to be calculated, and if it is compound interest, the words calculated daily and compounded monthly should be added. The cost of the warrant plus VAT. Payments made by the debtor. It is absolutely essential that the amounts reflected on the warrant be correct. So as in the case of Sonia versus Linton, it was decided that only one warrant may be issued in each case, and only the amounts appearing on the warrant need to be paid. Once that amount has been paid, the warrant has to be satisfied. That is the end of the matter. So you must make sure that you specify the correct amounts in the warrant so that you don't risk losing costs in your matter and lose money for all the work that you've done. Rule 41, execution against movable property. In terms of Rule 41, subsection 1, the sheriff must demand payment of the amount due to the debtor, or else that so much movable property be pointed out. The sheriff may deem sufficient to satisfy the warrant. If the debtor does not point out the movable property, the sheriff may go ahead and attach any property that he can find, which is in his opinion will be sufficient to satisfy the warrant. And then Rule 14.2 authorizes the sheriff to open any door, any premises, or any piece of furniture. If opening is refused, or if there is no person present who represents the execution debtor, the sheriff is also authorized to use force. To that end, if necessary, after service of the warrant, the sheriff provides the execution creditor or his practitioner the return of service together with an inventory of the attached goods. All kinds of movable property may be attached, including money, checks, security bonds, right, and a title in agreements such as credit agreements, for instance. Steps to be taken to ensure a valid sale of the movable property. The sheriff may, upon return request of the creditor or his legal practitioner, remove the attached goods to a place of safety. Upon removal of the goods, the sheriff will usually require the creditor to provide security in terms of Rule 38. The cost of removal and storage are high, but leaving the attached goods in the possession of the debtor carries the risk that the debtor may move. The sheriff's reply to the request for removal of the goods will indicate the date and time, place, and sale. Where he requires security, the amount of such security shall be, whether he requires the sale to be advertised in the local newspapers. The creditor or his legal practitioner must thereupon draft the notice of sale. Provide the sheriff with 3 copies thereof not later than 10 days before the date of the sale. Arrange the necessary advertisement to be published timelessly. The sheriff must be provided with a detailed statement of account before the sale takes place. The sheriff will recover the cost together with the capital and interest that the proceeds of the sale is sufficient to cover and the full outstanding amount. The legal practitioner of the creditor should attend the sale if possible. Rule 43 and 43A, execution against immovable property. Subject to the provisions of Rule 43A, no writ of execution against immovable property of any judgment debtor will be issued unless there is a nulla bona return or the property has been declared especially executable by the court. The forms or the format of the application is set out in Form 1, Section Form 1B. This application must be served on the judgment debtor, any other affected party, preferent creditors, the local authority, the property is rated, the body corporate, if the property is a sectional title unit. It must be served on the debtor personally by sheriff. The court must establish whether the immovable property which the execution creditor intends to execute against is the primary residence of the judgment debtor, and consider alternative means by the judgment debtor of satisfying the judgment debt other than execution against the judgment debtor's primary residence. Every application shall be supported by the following documents, where applicable: evidencing the market value of the immovable property, the local authority valuation of the immovable property, the amounts owing on the mortgage bond registered over the immovable property, amounts owing to the local authority as rates and other dues, amounts owing to the body corporate as levies or any other factor which may be necessary to enable the court to give effect to sub-rule 8. A court considering an application under this rule may, at its own accord, on application of any affected party, order the inclusion in the conditions of sale of any which may consider appropriate, order the furnishing by municipality of rates due to it by the judgment debtor or body corporate, or levies due to it by the judgment debtor. Order execution against the primary residence of a judgment debtor if there's no other satisfactory means to satisfy the judgment debt. Set a reserve price. Make any other appropriate order. In deciding to set a reserve price and the amount at which the reserve price is to be set, the court shall take into account the market value of the immovable property, the amounts owing as the rates and or levies, the amounts owing on registered mortgage bonds, any equity which may be realized between the reserve price and the market value of the property, reduction of the judgment debtor indebtedness on the judgment debt, whether or not equity may be found in the immovable property, whether the immovable property is occupied, persons occupying the property, and the circumstances of such occupation, the likelihood that the reserve price is not being realized, and the likelihood that the immovable property is not being sold. Any prejudice which any party may suffer if the reserve price is not achieved, or any factor which in the opinion of the court is necessary for the projection of the interest of the execution creditor and the judgment debtor. The reserve price is still not achieved. At a sale and execution, the court must, on consideration of factors, order how the execution is to proceed. But the reserve price is not achieved. A sale in execution, the sheriff must submit a report to the court within 5 days of the date of the auction. The report shall contain the date, time, place where the auction was conducted, and the names, identity numbers, contact details of the persons who participated in the auction, the highest bid or offer made, and any other relevant factor that may assist the court in performing its functions. The court may order that the property be sold to the person who made the highest bid. Once the court has granted an application for the sale of the immovable property, a writ of execution can be issued. The writ corresponding substantially with Form 32 shall contain full description of the nature, magisterial district, and physical address. It must be served on the owner, register of deeds, and occupier. The service must be done in terms of Rule 9. The sale is done by a third party that is not the bondholder, then the writ must be sent to the preferent creditor and local authority or body corporate as well. The preferent creditor must consent to the sale of or provide a reserve price. The writ can be served on the preferent creditor by registered post. The date of the sale must not be less than 45 days after the warrant was served. 35 days before the sale, the conditions of sale must be delivered to the sheriff. Interested parties may amend conditions 25 days before the sale. 20 days before the sale, sheriff settle conditions. The condition lay 15 days for inspection at the sheriff. The sheriff must serve the conditions 15 days before sale. An interested party can apply within 24 hours notice to change the conditions of sale at the magistrate court. It must be done 10 days before the sale. Execution creditor must draft notice of sale which contain a short description of the property, situation, street address, time and place of the sale. The conditions of the sale may be inspected at the sheriff. Or may be inspected at the sheriff. The sheriff must serve a notice of sale 10 days before sale on other judgment creditors who attached the property. Every mortgagee, all other sheriffs appointed in the districts, the sheriff shall affix a note to the notice board of the magistrate court and place of sale. The execution creditor must publish the notice of sale in the Government Gazette and the newspaper in the district not less than 5 days or not more than 15 days before sale. Please note that the provisions of the Consumer Protection Act are also applicable to sales in execution. Now let's look at Section 65 proceedings. Section 65 creates the procedure to bring a debtor before the court for a financial inquiry to enable the court to make an order for the payment of a debt in installments. The following important features of these proceedings: the debtor personally or a director or official of the debtor must appear in a court on a specified date for an inquiry into the financial affairs of the debtor. The court where the debtor resides or is employed has jurisdiction to hear the matter. In the case of a juristic person, the court in which the registered office, the principal place of business, is situated has jurisdiction to hear the matter. The debtor may be ordered to pay the debt in specified installment, and if it appears that the debtor owns assets, the court may authorize a warrant of execution to be issued. The debtor or representative may be ordered to bring specified documents to the court. The debtor may be ordered to pay the debt in specified installment. And if it appears that the debtor owns assets, the court may authorize that a warrant of execution be issued. The court may also authorize an emolument attachment order. And only other remedies available to the creditor are garnishing orders and sequestration of the debtor. Let's continue with the Section 65 proceedings. After judgment, the creditor must send a letter in terms of Section 65A to the debtor by registered mail. The letter must set out all the terms of the judgment and require the debtor to pay the debt within 10 calendar days from the date of posting the letter. The debtor must also be informed of the consequences of his failure to pay the debt. Excuse me. After the expiration of the 10-day period, the creditor may issue a notice to appear in terms of Section 65, subsection 1. The following amounts must be reflected on the notice: the capital, judgment cost, interest rate, date and rate, cost of Rule 45 certificate, cost of Section 65A, subsection 1, notice, cost of Section 65A, subsection 2, letter, payment made by the debtor. The fees and disbursements must either include VAT or the VAT must be reflected separately. So the Section 65A notice must be served on the debtor by the sheriff, the legal practitioner for the judgment creditor, or a candidate legal practitioner in the employ of the legal practitioner at least 10 days before the hearing. If the court is satisfied that the judgment debtor had knowledge of this Section 65A notice and that he or she failed to appear in court on the date and time stipulated, or if he or she was, if the case was postponed in the judgment debtor's presence and she failed to appear on the subsequent date, or if the judgment debtor failed to remain present at the court may, at the request of judgment creditor's legal practitioner, authorize the issue of a warrant of arrest. The warrant must be issued by the judgment creditor's legal practitioner and signed by both the legal practitioner and the clerk of the court, and will be executed by the sheriff. A person arrested under the warrant must be brought before a court as soon as reasonably possible. Such a person may be detained at a police station pending his or her appearance in court. In terms of Section 65A8, Section B, in lieu of arresting a person, the sheriff may, the judgment creditor or his or a legal practitioner consents thereto, hands to that a person or notice in writing which specifies the name, residential address, and occupation and status of that person, calls upon that the person to appear before the court on the date and time specified. Notice contains a certificate signed by the sheriff to the effect that she or she has handed the original notice to that person, that he or she has explained to that person the import thereof. A person who has willfully failed to appear in a court, as set out above, shall be guilty of an offense, liable on conviction to a fine or imprisonment for a period not exceeding 3 months. And then Section 65 therefore creates a criminal offense, and the inquiry into the judgment debtor's failure to appear in court, the circumstances set out above, takes the nature of a criminal inquiry, and the court must have due regard to the right of accused person to be presumed innocent, to remain silent and not to testify, to adduce and challenge the evidence, and the right of the accused person to be complied, to give to comply, not to be compelled to give self-incriminating evidence. Let's look at Section 106, penalty of disobedience of judgment or an order of court. Any person willfully disobeying or refusing or failing to comply with any judgment or order of a court, or with a notice lawfully endorsed on a summons or rent prohibiting the removal of any furniture or effects, shall be guilty of contempt of court and shall upon convictions be liable to a fine or imprisonment or for a period not exceeding 6 months to such imprisonment without the option of a fine. Knowledge of the judgment order is obviously necessary before it can be said that a party has willfully disobeyed it. Section 65J has also been amended as follows. Emolument attachment orders shall not be issued unless the judgment debtor has consented thereto in writing or the court has so authorized, whether in an application to the or otherwise such authorization has not been suspended. Whether imported amendment is contained in 65J4, judgment creditor or his or legal practitioner shall, at the reasonable request of the garnishing or the judgment debtor, furnish him or her fee or have a fee of charge with a statement containing particulars of the payment received up to date, concerned, and balance owing. Section 65, proceedings with regarding to emolument attachment order.